I'm an attorney from Boston. I work for Foley and Lardner. I'm an intellectual property lawyer, patent attorney there. I do mostly litigation work, clients with litigation as well as counseling on avoiding litigation. So have a strong interest in AR and IoT. I guess AI, as we call it in Boston, would be more accurate. But we'll just go down the panel here and then we'll get started.
Sure, thanks. I'm Shabbi Kahn. I'm an IP counselor, patent attorney at Foley and Lardner as well. Luke and I have been really excited about AR, and so we've been spending a lot of time going to these events and trying to help companies sort of protect their ideas in this space. I think there's a bright future. It's still very early in terms of like the innovations that are coming out of AR, so there's a lot of white space out there to capture, so you guys should keep innovating.
My name is Jordan Schwartz. I'm the general counsel at Meta. I've been with the company for about 4 years now, and kind of beyond just the general legal work that I do, I've been heavily involved with general business operations, finance, fundraising, kind of running the gamut.
I'm Steve Cohen. I've been practicing law for 12 years, technology law primarily, intellectual property. I specialize in open source technology, and I work for a open text corporation, which is believe it or not, the largest software company in Canada that nobody has heard of. But we specialize in enterprise information management, and I've heard that buzzword a lot tonight, or today. And we just acquired Dell EMC's enterprise content division, so we're one of the major players now in that space. But before I was an attorney, I was a programmer in the VR, AR space way back. And has anybody heard of the Cave? Yes, excellent. Well, I was one of the original programmers for the Cave at the University of Illinois. And I'm pretty confident that I worked for a company called ElectroGig. We did the first ever virtual set technology live production in the United States. It was with John Stossel in 1996, so kind of way back. So yeah, that's it.
Thanks, Stephen. Yeah, so I think what we're going to do today is I'm going to talk about a couple of recent cases involving AR, sort of on the gaming side, people may have heard about, hopefully set a little context, and then we can talk about legal issues facing AR, so, or facing AR companies and the AR space. So. The first is one people have probably heard about. It was filed about a year ago against Niantic, the maker of Pokemon Go, by some private property owners in various states throughout the country, alleging that basically having these Pokestops or gyms on their property was a form of trespassing. So they filed suit in these various states, and the suits were consolidated into a class action in California. The theory being that Niantic was inducing folks to trespass on their property. I guess they had hordes of people walking on their property, blocking their driveways, relieving themselves in the bushes, et cetera, and they filed suit. So those are the allegations anyway. Niantic has said, well, we're not responsible for what these people do. They're free citizens. We tell them in our terms of use not to do these types of things, and if they choose to break the law, that's their responsibility. So it's an interesting sort of wrinkle in an issue that AR companies are going to face, I think, especially on the gaming side going forward. However, there's a second piece of that case that I think is probably more relevant to folks in the room, and I think a little more of an innovative argument by the plaintiffs' lawyers, and probably why people hate plaintiffs' lawyers. The argument is that by placing these stops, these Pokemon on the property, that itself is a form of trespassing. So basically virtual trespassing. So even though it's not a physical object that I'm placing on your land, by placing my Pokemon there, I know that I'm placing it there because Niantic controls what's going on the back end. That itself is a form of trespassing. As I mentioned, the cases in California, these plaintiffs are from different states. State trespass laws all vary from one to the next, so the California court's going to have to resolve whether that's a viable theory based on all these different state trespassing laws going forward, and that's actually going to be heard later this month in that California court, so we'll see what happens there. I was thinking about when Aaron from Google mentioned, walking into Lowe's and buying your hammer. Well, that sounds great. I go find my hammer. Well, what if Amazon chooses to push me a notification that I can buy that hammer from Amazon for $5 less? and I'm standing at Lowe's. I assume if I'm in the legal department at Lowe's, I'm going to find any way I can to prevent Amazon from doing that. So, you know, if me, Amazon, pushing that notification to you inside of a Lowe's is a form of trespassing, well, that's going to have, I think, broad repercussions going forward of what we can do on the enterprise side, you know, with AR. The second case I wanted to just mention briefly is filed much more recently by a company called Candy Lab, folks may have heard of, which released an AR video game at South by Southwest back in January. It's sort of a Texas Hold'em poker game where you go find different cards at different locations, so similar to Pokemon Go. Last summer, the city of Milwaukee, I guess, had a big problem with folks playing Pokemon Go in parks and staying beyond the park hours and, again, trampling the daisies, et cetera. And so they passed an ordinance saying if you're going to publish one of these games and you're going to attract people to parks, you need to get a permit first. And, you know, if you're going to, we'll review your application and we'll give you the permit, and you have to abide by the rules of the park, et cetera. And if your players don't abide by the rules, you are held liable for that. Well, Candy Lab filed suit alleging that's a violation of the First Amendment. So, as we may recall from our ninth grade civics class, the First Amendment protects everyone's right to free speech, and that includes publishing of a video game. That's a form of speech. So, this ordinance sort of purports to say you can't have the game in our park. It doesn't sort of try to prevent the folks from walking into the park. It prevents the speech from happening in the first place. So that's potentially the issue. So again, that case just got filed. Milwaukee already responded to an early motion. There was a hearing where the city already indicated, well, we might change the ordinance to make it maybe less vulnerable to a First Amendment challenge. But I think it's clear that municipalities are going to try to regulate in this space. Whether it's by preventing these games from being released or being utilized in the city as Milwaukee has tried to do, or just preventing the behavior that the games induce. There's going to be regulation out there that companies are going to have to contend with. So, all of that I think is a very long way of saying. Maybe I'll start with you, Jordan, since you're the GC of Meta. I'm sure you wear many different hats. It's a very uncertain legal landscape out there. As the general counsel at a company like Meta, it's growing very rapidly. How does that affect your job? And what's keeping you up at night?
Yeah, so as you can imagine, 4 years ago when I joined Meta, we were a 12-person organization, operating out of a house in Silicon Valley. So, a lot of the early, years, and it's still maintaining this, just setting the foundation for the company to operate in a way that protects, primarily our intellectual property, but avoids all the legal pitfalls that any company scaling will face. So, everything from NDAs and IP assignments and that kind of basic stuff, and of course patent filings. So one of the exciting areas of being a company like Meta that is a full stack hardware, optical engine, sensor array, computer vision, operating environment company is we are innovating in all areas of the technology, and so we're in a unique position to actually be able to be at the fore in terms of the ideas that we're able to implement on a day-to-day and week-to-week basis. And as as any organization, there's always going to be tug and pull between legal departments and sales departments and CEOs who want to show off the latest technology to audiences. And just a recent example, we were fortunate a couple weeks ago to win the Best in Show at the Augmented World Expo. And what Mayron, who many of you saw yesterday present, was a similar kind of presentation, was many applications or widgets that were created in an internal hackathon we had just a few weeks ago. And so as a legal department, naturally you're always concerned about, well, there's some really great ideas being generated here, and now you want to go out and just show it publicly. But that's the challenge for us, and we take that on ourselves to say, okay, this is really what the organization needs to get our vision out there. And so as the legal department, we say, okay, well, give us it. We'll work with our patent counsel, and we'll get things filed so that we're all protected.
Very good. Well, Shabbi, I think, is going to talk a little bit more about patents specifically a little bit later, but I wanted to go to you, Stephen, because OpenText is a company, he mentioned that's one of the largest in Canada, or the largest software company in Canada. You guys have grown largely through acquisitions, strategic acquisitions. So, maybe you could talk about, what you guys look for, in an acquisition target, maybe even, what you don't look for, what some red flags might be, and sort of what you've seen over your years of the company.
Well, there are a lot of aspects to mergers and acquisitions. There are a lot of reasons companies want to buy other companies, obviously. But so we make sure their house is in order. We make sure there's no litigation against them that's going to jeopardize when we take over their business. We check all their licensing. And I know a lot of people here are involved in software. So one of the primary issues is open source software. And it's ubiquitous. Everybody's using it. But a lot of companies are very unsophisticated about how they use it, and it can really get them in trouble. And so one of the things we look for is to make sure that their open source usage is in compliance and they have processes set up. And if they don't, we try to figure out what the risk we're inheriting might be. Plus, not only that, but we license our software. And so a lot of prospective licensees are very concerned about open source and certain types of licenses, like the share and share alike license, which we could have a whole panel discussion just on that. But so they generally will not license our software if we're using share and share alike open source. So we have to come up with a plan to either license that software commercially, or just get rid of it, or explain to them that it's not going to conjure up the offensive parts of that license. So it's just it's also just to make sure they're everything's IP, the software, just to make sure that everything's well managed and they have an accounting of all of their software, and it's all in good shape, so we can take it and run with it. So.
Yeah, and I want to get you in here, Shabbi, because that sort of dovetails nicely to another point. I mean, I think people may have heard that software is not patentable anymore, or it's become a lot harder to patent or protect. Maybe you could just speak to that a little bit, sort of how the law has changed, strategies that companies should be thinking about for protecting their IP.
Sure. So I'm assuming some of you at least must have heard about a recent Supreme Court decision called Alice versus CLS Bank, and it basically reduced the number of patents that were being allowed by like over 50% in the software space. And the reason that, we sort of like cringe at the idea that they're being so draconian about the way they basically came out with that decision, but the idea was that what previously people were filing on pretty much anything. So you could try to protect the idea of displaying, like in an AR example, the idea of displaying calorie information on a menu on a board. And like you would try to get a patent on some really broad concept along those lines. So the court basically said that, well, that's just sort of too broad. It's just an abstract idea. And so they've basically tried to like curb the scope of what these patents can look like. And the way to get around that is basically focusing on some of the technical problems and challenges that are associated with those sort of, implementations or applications, and then drafting claims or patent applications that are addressing those, providing technical solutions to that. And to run with just one quick example with the calorie information, what you really have to do is when you're doing that, you scan your phone on a menu board. The device is going to look at some sort of, computer vision recognition techniques to like identify different objects on the thing, retrieve some information from a database to see what matches, pull up calorie information. Now you want to present that back on your AR environment, but now you have to place those labels in a place that's not obscuring the view. So it becomes a lot more technically, novel and unique, and those are the kinds of inventions that people should start to think about filing, as opposed to the broad idea of, I have, calorie information I want to present.
Yeah, computer vision algorithms are really critical to the success of AR. These are, the same sorts of algorithms that, Tesla is using to enable self-driving cars, self-guided robots or drones. It's using sensory data in our device. The sensors are sitting in the brow of the headset, and to track your environment for spatial tracking, world tracking, in our case, also hand tracking. And so this enables you to place digital information in your environment, have it register and stick to the environment in a place that now you can go walk around and have that digital object where you left it. And as I mentioned before, also on the hands side, the ability to track your hand so that you can manipulate it as though it's like a real object.
Yeah, hop in here too, Stephen. I mean, is Alice affected how you guys at OpenText are viewing
yeah,
what you're trying to protect?
Yeah, absolutely. I mean, we go, whatever our core technology is, we mine it and we try to file patents on it in every which way we can. You know, you want to protect your core technology, period. You want to at least do that. And it's been a challenge. There's almost been like a full court press against patents in the last half dozen years. Not only was there that Alice decision, but there's been many follow-on decisions. And the America Invents Act, which was passed by the Obama administration, I don't know, what,
Right.
it created a lot more ways of challenging existing patents that were pro-defendant. But you know, you certainly software is entirely 100% patentable if it represents an improvement to the technology in sort of an unconventional, non-routine way of doing something using software.
When you mentioned core, sorry to cut you off. You mentioned core, core IP. I mean, there's a lot of folks here at startups, and they don't have unlimited legal dollars to spend. So how do we decide what's our charter period? What's core? What's core, non-core? These are terms
yeah,
that
that's
we
a good
throw
question.
around.
Well, you want to focus on what your business is focusing on, and you want to focus on the markets that are important to you. Whether it's the United States, Europe. So, if your primary market is in Japan, you might consider filing patents in Japan, and China's becoming a much more important jurisdiction these days.
Right.
Yeah.
Yeah, sorry, but I think one of the things to also recognize is depending on where you are in your growth cycle, are you emerging tech or are you an established company that's got a lot of applications already on file, you sort of have to decide where to spend your money. And so if you're a startup, you really focus on what's core to my business and where do I want to basically preserve my space. Once you become larger, you're now thinking more defensive. How do I prevent somebody, larger company coming back and suing me? So you'll try to, create avenues to create assets that you can then leverage against them for licensing agreements or cross-licensing plays.
Yeah, and as
Jordan,
mentioned before, you could imagine for a company like ours, this includes technologies like around the optical engine, like with the computer vision, but then, subsidiary technologies that are necessary for the function of the device, like, CPUs, GPUs, battery life. Obviously, those are things that we're not going to be, gaining headway on. We're not adding value to the value chain. And, from a, legal, economic standpoint, a lot of this comes down to what is your cost to develop it, and what would it look like to license it too. And so understanding your core, and then understanding where you're adding value to this new market, and where can you go out and find substitutes that might be a lot more cost effective than actually developing it yourselves.
So do you have, Jordan, at Meta, do you have regular meetings with developers to make sure that the sort of corporate strategy aligns with the legal strategy on that
Yeah,
front?
all the time. There's definitely an aspect of the job where you feel like you're a bit of a policeman too. Making sure you're keeping on top of folks about all the latest and greatest ideas. And we also interact closely with a lot of third-party developers and with a lot of large companies, vendors that might be making semi-custom or fully custom components for us. And the division of intellectual property and ownership rights is always a major sticking point when we're negotiating these agreements.
And that's a good point you bring up. And that could be a whole other panel as well. If you're working with developers abroad, oftentimes the employment laws of those foreign countries apply, and so you have to worry about what's a work made for hire. Have you gotten the assignment that you needed to get under those foreign laws? So again, this is probably a panel for another day. But I guess just finally, because this is it's obviously primarily a tech conference. Jordan, you mentioned on a previous call that we had that you've been doing legal work with your Meta glasses. I'd just like to hear sort of what you're doing. What kind of legal work you're doing, how you're using Meta in your everyday job.
Sure. Well, you guys might have saw when Marone was presenting our workspace. There are kind of two broad categories of applications that we're building natively. One is primarily geared towards 3D model viewing, creation, sharing. And the other is kind of a simple panel viewing experience. And so as a lawyer, I kind of fall in that latter category. Someone who just reads a lot of documents throughout the day. Have your array of monitors set up on your desk. Maybe your stack of papers as well. For me, I've been working a lot, without any of those monitors in my environment, with a completely cleared kind of office space, and I find it quite fulfilling. And actually, when people pop in, regularly to my office, it's kind of interesting because I'm able to, have my workspace set up in front of me, and then without even taking off my headset or anything. And one of the benefits of AR being completely transparent, I can have a conversation with them, place my information, to the side of me, complete, whatever it is we're discussing, and then I'll go back to my workflow.
Very cool. Well, thank you all very much.
Yeah,
Thank
thank you.
Woo!